Okay, let me pull it up on there. So how's everything going for you guys? Well, never mind. I know how everything's going. So chaotic.
Yes.
Let me close out everything.
I had a couple of additions, so as we go along, I'll let you know which ones. Since we last talked, there have been a few payments and
Okay.
entered. So.
Okay. Actually, can you hang on a second? I think I printed out some stuff, and let me see what I printed out. I'll be back. I don't know if I printed out the pretrial list or not. So give me a minute. I'm sorry, Mary. I should have printed out the list, but I didn't bring it with me. So
okay,
we'll go ahead and go through it then. I'll just go through the list.
okay.
So Kendra, Ace. Okay. Why don't you, if they paid, why don't you tell me that they paid? Otherwise, I will go ahead and find them in default.
Okay, all right.
For Kendra Ace, I'll find in default.
Okay.
Candy Anderson, I'll find in default.
You paid that. That's
Okay.
A bond forfeiture.
Okay, so we'll switch that to a bond forfeiture. Face them on the citations on all these citations unless noted otherwise. James Anderson, default judgment. Ariel Annan, default judgment. Willard Bellin, excuse me, default paid. Okay, bond forfeiture. Tiffany Betts,
also paid.
Bond forfeiture. Amanda Burian,
Paid.
Bond forfeiture. Michael Cady, default judgment. Cesar Cervantes,
He paid.
bond forfeiture. Angelette Clark, default judgment. Emily Consini, default judgment.
She's not on the list.
Oh,
yeah, some of these that have entered a not guilty plea, the report is there. So this is.
Has Ms. Consini entered a not guilty plea?
Yeah, she's not on the list. The report is there, but she's not scheduled for tonight.
So I'll accept the not guilty plea and we'll schedule this matter for a pretrial conference.
It's okay.
Already done. Okay, good.
Yes.
You're too efficient for me, so thank you.
It's been a while. The next one should I maybe say the names for you?
Yeah, why don't you?
Okay, that just so to avoid saying some of these names that I don't know if you want them on TV.
Right.
Bethany Darling, she's a default.
Okay.
Adam DeRocher, he paid one of them.
Okay, so we'll forfeit the bond on the one and find him a default in the other.
Okay.
If you want to just read out the name, and if they paid, okay. I'll go ahead and enter the disposition. I'm sorry.
Dorenzo did not pay.
Default judgment.
Thomas Dreisen did not pay.
Default judgment.
Ricky Frayne did not pay.
Default judgment.
Michelle Fyan did not pay.
Default judgment.
Josh Giebner did not pay.
Default judgment.
Stu Grover did pay.
Bond forfeiture.
Alec Preston paid one and default on the other.
Okay, well, so ordered that on one citation and default on the other. And then is our next one Mr. Hammis?
No, Mr. Hammis has entered a not guilty plea.
Okay.
So he's not appearing. The next one is Chandler Hansen,
Okay.
and that was, he did not pay.
Default judgment. Can you hang on a minute?
Mhm.
Let me find my place. Okay. And then the next one, please.
Edward Hyman, he has entered a guilty plea, and his plea sheet should be in your file there.
It is. Let me take a look.
Okay.
Okay, so did he receive 2 citations?
Yes.
Okay, according to this, he registered right away. So let me take a look at the citations. He didn't know what to say about the seatbelt violation. So I'll find that for the non-registration of auto that he registered it the next day and pursuant to city policies, or that he did register the car. So for that citation on the court's own motion, the court moved to dismiss the operating address or the registration citation.
Okay.
And as far as the seatbelt violation, was that a $10 forfeiture?
Correct.
Okay, the court will find him in default of the $10 forfeiture and order that he paid $10.
He entered a guilty plea, so.
Right. Oh yeah. So we'll find him, accept the guilty plea on the seatbelt,
Okay.
find him guilty, and find him the $10.
Thank you. Okay. The next one would be Melissa Hendrickson. She paid.
Bond forfeiture.
And Jerry Hicks has 3. He did not pay.
Default on all 3.
Jeff Hines paid.
So forfeit the bond.
Daniel Hoffman did not pay.
Default judgment.
Aria Rose Yellowbird paid.
Bond forfeiture.
Michael Johnston has entered a not guilty plea tonight and will not be appearing, but I'll get that scheduled for a pre-trial.
We'll schedule, yeah, well, the court will accept his not guilty plea.
Okay. Timothy Jowett, he paid.
Bond forfeiture.
Andrew King did not.
Default judgment.
Miranda Kittleson,
Plea
she
sheet.
has entered a guilty plea. However, she has provided proof of both registration and insurance, and those are in your file.
Okay, I'm taking a look at that. Okay, on the court's motion, both citations for the citation for expired registration and what was the other one?
Operating without insurance.
Operating without insurance. On the court's own motion, both citations are dismissed.
Joseph Anthony Cook did not pay.
Default judgment.
Madeline Kuma paid.
Bond forfeiture.
Janelle Lindeman has entered a no contest plea, but there's no extra explanation, just that's the plea.
Court will accept a no contest plea, find her guilty, and impose the face amount of the citation.
Ronald Long did not pay.
Default judgment.
Osman Maharana entered a no contest plea, and there's a plea sheet with an explanation in
All
your
right. Yeah, let me take a look at that. Okay. I'll accept the no contest plea and find her guilty and impose the face amount of the citation.
Michael Madison paid.
Bond forfeiture.
Marquitas McLaurin did not pay.
Default judgment.
Kevin Monson did not pay.
Default judgment.
Suzanne Nordine did not pay.
Default judgment.
James Nowlin paid.
Bond forfeiture.
Chad Osman did not pay.
Default judgment.
Jennifer Perkins did not pay.
Default judgment.
Michael Pinkston did not pay.
Default judgment.
Andre Porter did not pay.
Default judgment.
Jessica Reeves did not pay.
Default judgment.
Dale Rush did not pay.
Default judgment.
Shaylin Rudolph did not pay.
Default judgment.
Gabriel Shoemaker did not pay on both citations.
Default judgment on both citations.
Lily Sorensen did not pay.
Default judgment.
Vivek Tara did not pay.
Default judgment.
Elizabeth Tesler paid.
Bond forfeiture.
Michael Toby did not pay both citations.
Default judgment on both citations.
Jared Torblow, upon the request of the city, they would like that dismissed.
On the motion of the city, the citation against the defendant is hereby dismissed by order of the court.
Michael Trumpy paid.
Bond forfeiture.
Pablo Valencia did not pay.
Bond forfeiture. Excuse me. Default judgment.
Wade Voss did not pay.
Just a minute. Oh, okay. Let's see. He did not pay, so default judgment.
Brian Wadzinski did not pay.
Default judgment.
Brandon Weezer did not pay on both citations.
Default judgment on both citations.
Clifford White paid.
Bond forfeiture.
Tinia Williams did not.
Tiana Williams, what did she pay?
Did not.
Default judgment.
And Brianna Zimmerman did not pay.
Default judgment. Now you know how well your voice gets sore after a while. You know. Sorry about that. I printed off all the stuff for the trial, but not the pretrial conference.
Okay. And that was it then. Anybody else that you see they're scheduled for pretrial?
I did not, and I went through the list, and there are a few on the list that you mentioned that weren't on my list. Then so.
Okay.
And if we miss any, we'll go ahead and forfeit the bond or default judgment as appropriate. And again, my policy for this will be if anybody didn't realize they got a citation, they're encouraged to file a motion to reopen. We'll take a look at it then.
Okay.
Realize the Zoom appearance, especially this week with all the internet down, that some people might have might have attempted to get through and were unable to do so.
Right. And 60 days to pay.
Correct.
Okay. All right. So that's it till 6.
Okay. Court's in recess until 6 o'clock. I'll see you then.
Okay. Thank you.
All right. Thanks, Mary. Bye.
Bye-bye. Hi, Amy.
Hello, how are you?
I'm good. How are you?
Pretty good.
Are you? Yeah. Hanging in there, huh?
I know, I'm officially like 9 months now, and I'm like, okay.
Oh, that's what I thought. I was
Woo! Yeah.
surprised that you were going to be here tonight.
Few weeks to go.
Wow.
Assuming she doesn't come early, I'll do the pre-trials the first week of March as well.
Okay. All right. Yeah, you were due the 13th, right? That's what I had. Okay. All right.
Yeah. Yeah, unless she makes an early appearance. We'll
Okay.
see.
All right. That sounds good.
Which at 36 weeks, you're like, that's fine. You can
I
come now.
know.
Sure.
You're not kidding. I know
Yeah.
that feeling. Oh, that is the worst. It seems like 9 months. You don't think it's how long that is, but it really
is, especially with time standing still during COVID.
That's true. That's just that. What a crazy time.
Yeah.
Yes. Ugh.
But yeah, the Pahua is going to be taking over for me while I'm on leave. And
How do you say her name again? Pahua?
Pahua, yeah.
Okay.
She's actually going to watch the trial tonight.
Okay.
Oh, I'm going to feel that. I should have asked her how to pronounce it for sure. I think it's Tao.
Tao. Okay.
Yeah.
That's what I thought. Okay. Yeah, because Sammy had sent me an email saying she would be observing. So I'll keep an eye.
So she did pre-trials with me 2 weeks ago. We just did it in the office. So so she's up to speed, and she already does pre-trials in a few other municipalities, so she should be able to jump in.
Oh wow, very good. Okay, good.
Yep.
Okay. Well, that's nice. Good.
Yeah.
Then you're lucked out.
Yeah.
We've got one coming up where the woman, without saying any names, she is dating a police officer in Madison, and she is saying that her car was issued a ticket for non-registration. Her daughter was driving, and she thought that because of COVID, there was a law that they couldn't give these tickets. I checked with the PD. I just asked Lieutenant Conlon, and he said he didn't get specific, but he said he thought it had been expired, that it was over.
Oh, okay.
I don't know. Just give you a heads up. She'll be making an issue of that. So.
Oh, actually, that's really helpful. I'll see if I can do some research and
exactly.
find out if that existed, and if it did, when it expired. Okay.
Yeah. She had said something to do with, I think I have it all written down for you, something, the emergency management chapter 32 or 33, something of Dane County. So she's.
Because it was hard to get to the DMV, and
right.
Got it. Okay.
Okay. All right. Just waiting for Judge Rothy. He should be here any minute.
Do we have a hearing at 6?
We do, but I don't believe she's going to appear. She had been given 3 months to register her car, and I did a check at the DMV or register her license. She's revoked, and she did not do that, so I don't think she will be appearing soon.
Gotcha.
Okay. You never know.
So Nick, a few of my associates are watching who are doing their first OWI trials, and I told them to watch you. So you have to put on a good show for them.
Yeah, no, I hope they're not watching me. This will be, they'll be let down.
We have a great defense attorney. This is actually a good one for you guys to watch. I'd rather they watch me do like a intense family law cross-examination or something. But they're less interested in that.
Well, we'll see. I've never done a hearing in my life from home. And I'm
Really?
doing this one. Never.
What have you been doing since March?
I go
All
to
in
work every
person?
day. Well, I go to work every day.
Oh, go into work. Okay, because this is later.
I've
Got it.
never
Okay.
it's never even crossed my mind to do this. So we'll see how this. The lighting. I feel like I'm being examined by a police officer.
You got to do it right. What do you thinking?
Yeah, but if I looked like you, I'd be happy to do that.
I know. That glowing complexion.
Is it being super pregnant? Is it a ring light? Who knows? Who can say? No, I teach a class at the gym virtually, so that's actually why I ended up getting this. It's less blurry when you're moving if you have like a bright light on you. So it was not just my court vanity. It doesn't hurt, but yeah.
I find myself to be better. I get much better looking when I go like this.
Oh,
There you go. Yeah. I have like 50 lipsticks that are just the Vapor lipstick. It's all sitting in the drawer. No use. So sad.
I got caught the other day we're working remote, so I'm at home and they were doing an upgrade to my computer. And the guy is like, something is on your keyboard. I can't go on. And I looked down and it was the sleeve for my bathrobe. It was like a heavier bathrobe. And that was like in the middle of the afternoon, So whoops. Oh.
I do all court from this room now with the Christmas lights.
Oh, yeah.
Because during the day I have the sun and we don't usually have this, but it's the only room that my voice isn't so loud it drives my husband insane. So this is.
So you're not going into working? You don't?
Not at all. Yeah. Well, and part of it is being pregnant and being active.
Yeah, I can imagine.
Yeah.
And I have some children that are home, so I don't want to be home. You know what I mean? Like they're trying to do work on like this computer has my son's information on it, and it's like,
I'll watch those filters,
Yeah.
Yeah, if something pops up that's wildly inappropriate, I'm just gonna say it's his, but
the only thing that's hard is when my husband and I both have Zoom court. Like that is about as much as our internet can handle. So we have to try to alternate or be closer to the, that kind of thing. So we just have that worked out every morning. Okay, when is your court? He has way more than I do, so we just have to make sure it doesn't conflict with mine for the most part. But yeah, that part's not fun.
Is anyone familiar with the name Abigail Ruff? She's tried to enter.
That's one of the witnesses.
Okay, so I will admit her then. Okay. Where did she go? Looks like she might have a slow connection. It's like spinning. So. Oh, there she is. There she is.
Okay, great. Good evening. Can you guys hear us?
Yes.
Good. Okay. Do I have Abigail and Katie?
You do, yes.
Okay. Excellent. From one space. Easy.
Yeah.
Thank you. We're just waiting on the judge and then we can get started.
Okay.
Okay, and now I have, okay, this is your assistant, Pehua.
Yes,
So I will admit her.
you
And
better
then-
say associate or she's a lawyer. She's not gonna want to be called an assistant.
Okay, I'm sorry. Oh, boy. And then a phone number, 608-622-4930.
I'm assuming one of the officers.
Okay. Oh, okay.
Yep, so we should have two officers calling in or
Okay.
zooming or calling in.
Hello?
Hi, is this the 608-622-4930?
Yes,
I am wondering if I can get a name.
sure. Kelly Dugan?
Oh, okay, Kelly, you're the 6 o'clock hearing. We're just
Right,
waiting on
right.
the judge.
Oh, okay. No, that's totally fine.
Okay, all right.
Is this Mary?
Yes, it is, yes.
Hi,
Did-
Mary.
Hi, did you
It's
happen
always a pleasure to speak with you.
Oh, did you happen?
Always. I'm telling you, you are the nicest lady.
Oh, I don't know, my husband wouldn't agree, but,
Well, listen, I'm divorced, Mary, so my ex-husband wouldn't agree either. And let me tell you.
Oh,
I love being here in Stoughton. I love being here in Stoughton, and I made a wrong choice. And so, I want to make things right.
did you have a chance to reinstate your license?
Well, what happened was, I am, almost 60 years old, and I'm on disability from an accident that I had. I did get the interlock thing put in my car, and because of COVID, I voluntarily, since I ran that stop sign, remember? Well, you probably don't remember. Of course you don't. But back in when I moved here in Stoughton in August, I ran a stop sign at 26 miles an hour, and I had like 0.2. And so I voluntarily put myself into a class called ART, which is an alcohol, because of, an alcohol rehabilitation center. And
Okay.
so I love it, and I've been doing great and have remained sober because I was drinking like 2 to 3 times a week, to be honest.
Oh, boy.
I
Judge Rothy is here now, so I'm going to let him know what's going on. Judge Rothy, we have Kelly Dugan on the phone.
Okay.
She's the 6 o'clock hearing. She had a unregistered driver's license, and you gave her 3 months to reinstate. So she was just explaining she hasn't been able to do that yet. So if you want to take
Okay,
that.
so
first.
Ms. Dugan, you have not registered your vehicle yet?
Well, and thank you, Your Honor. I'm honored to be in your presence. Yes, I did have the interlock device put into my car. But the thing, I voluntarily, since I ran that stop sign in Stoughton, I put myself into a program called ART in September of last year. And so I have been participating in that and journey. I am on disability. I am a senior lady. I have 3 cats, and I was blessed enough to adopt 3 other kids and run a business in Madison.
Okay,
So I know how well respected you are. I know that, and respect is everything. And I've heard great things about you. So the problem with Journey is they want $200. My income a month is $850. My landlord has since, where I'm renting at on Moline Street, has passed away from COVID. He died in December.
okay. Ms. Dugan, let me interrupt you for a minute.
Oh.
What are you asking in the
Oh,
court
sure.
to do?
I guess, Your Honor, what I'm asking for is an exemption because this thing that was put in my car goes off every 4 minutes. And I would volunteer 300 hours in Stoughton. I would do anything. My cat was a volunteer at St. Mary's Care Center to visit with patients. The problem is I had this put in my car. It goes off every 4 minutes. And in Stoughton, when I had it put in, the horn goes off and I have to grab that. I'm an older citizen, and with Journey, they're asking for $200 that I don't have. You know, all I have is the $850 a month, and I'm trying to do right by you, and trust me, I am. And so, and then the driving class, I'm all signed up for it in March because I know I ran that stop sign, and I'm very sorry. I've never had a speeding ticket. I've never had any other problems. And so I guess I'm asking for an exemption for the monitor being put in my car because they say that you need that to start your car, but then it goes off every 4 minutes. And in Stoughton, what it does is your horn goes off, everything, and you're trying to grab that. And I'm trying so hard to concentrate on driving, you know, because I would never hurt anyone. And
Let me interrupt you,
and I
Ms.
can't-
Dugan. Ms. Dugan, let me interrupt you again. Mary, what is before the court exactly?
She had a ticket for operating while revoked. And you gave her 3 months to reinstate the license.
Okay, so it's not an IID issue, it's just the revocation. What's the city's position on her argument?
City takes no position, Your Honor.
Okay, and so Ms. Dugan, what I'm going to do, let's see, so you have you do not have a driver's license, is that correct?
Yes, Your Honor. No, I don't.
Okay, but this operating after revocation is just, you mentioned IID, is that with did you receive an OWI? A drunk driving?
Yes, yes, I did, and that was a very terrible mistake. Yes.
Okay. Given all this, because you are currently on disability, because you're in Journey, because you're not driving, the court on its own motion is going to go ahead and dismiss the citation just because you've done kind of what the court has asked, even though you haven't reinstated your license. You actually have you're not driving right now, and you're under the poverty limit anyway, so I don't think I can impose a fine. For all these reasons, the court on its own motion will dismiss the citation against you.
Thank you, Your Honor. Thank you
Okay.
so much. I really appreciate that. I've heard wonderful things about you. Let me tell you,
Well,
I have.
Well, thank you. Thank you. So, okay.
And there
any
is
further-
there.
Do you have any further
Well,
questions?
Well, I would like to ask something. Is it possible that I could get an exemption from having this in my car because or is that a whole separate situation?
Mary, was this citation
It was not I'm just verifying, but I believe it was not a Stoughton ordered for IID.
okay. Okay, so Ms. Dugan, the IID was issued from another court, so I don't have any jurisdiction or authority to exempt your IID from your vehicle. That would be another court.
Okay, sure. And I'm telling you, you know, I want to start volunteering here. I'm telling you, I've heard such good things, and I tell Mary, I just adore her. And the Officer DeVici, was so kind. And you know, I'm trying. Listen, I've been a law-abiding citizen my whole life, and yes, we all trip and fall. But Your Honor, thank you so much.
Since the citation has been dismissed, that will take care of it for this evening. And thank you, Ms. Dugan.
Oh, thank you. All right.
Have a
Bye,
good
guys.
night.
Thank you. You too. Bye.
Okay. All right. And then City Attorney Collins O'Hara is here, and Attorney Nick, I can never say.
Chirophacy, I bet.
Chirophacy,
It
thank
is,
you,
but-
is also here.
Yeah.
The
and
rest
I
are
didn't know you know this.
witnesses, so.
Nick is my son. You don't know Nick is my son, but Nick is my son.
I was going to say, I thought your name was Corey
Oh,
Chirophacy.
you did say, yeah, Corey.
But it's fine. I don't know how to get rid of Nick on here, so we're stuck with Nick. So.
Okay, so these are all witnesses for our trial then.
The rest are, yes.
Okay, all right, the court will call City of Stoughton versus Jody Risden. State your appearances for the record, please.
Attorney Amy Collins O'Hara appears for the city of Stoughton by Zoom.
Good evening, Your Honor. Ms. Risden appears by her counsel, Corey Schroffesi, who also appears via Zoom.
Okay, thank you. So we're here tonight for an OWI, operating while under the influence, operating with a prohibited alcohol concentration, inattentive driving, and failure to keep vehicle under control citations. Is that correct?
That's correct, Your Honor.
Yes, Judge.
Okay. And the parties have been unable to resolve this case?
Yes, Your Honor.
I've begged.
Okay. And so, Mr. Shropsy, you've been able to explain the trial procedures to your clients?
I have. She's well aware of them.
Okay, good. So, all right, since it's been resolved, I will note for the record that both sides are represented by attorneys, so I won't go through the normal explanation of a trial. Would the city like to make an opening statement?
No, Your Honor.
Mr. Shropsy, would the defense like to make an opening statement?
No, Judge.
Okay, the city may call its first witness.
Okay, so Your Honor, I have two private citizens here to be witnesses, so I'm going to let them go first. I actually have called both, and they are both in the same Zoom. I don't know if that's okay with the court for them both to testify, or if you'd like them in separate rooms.
I think it would be better if whoever is going to be called first, if the other person were to leave the room, just because I don't want anybody to suggest any type of testimony.
So I'd like to call. Oh, I'm sorry.
I'm sorry, Amy. Judge, I don't know how, I've never done this on Zoom, but I would move for exclusion. I don't know how you do that.
I think that, so you basically, I'll treat that as a motion to sequester witnesses. So Mary, if you could, for the plea, let's see, who is, I see Sergeant Bob Miller. You could probably put him in the waiting room.
Okay.
I'll grant, Mr. Shropsy, I'll grant your motion to sequester the witnesses. And then, let's see, I see Kyle Kneck. Is that another
He's an
witness?
officer
That's the
also.
officer.
Okay, so they can go into the waiting room, and then Ms. Thau, Mr. Thau?
That's an associate from my office who's just observing, Your Honor.
Any objection, Mr. Shropsy, to having the associate observe?
I have no objection to that.
Okay, and then as far as the Abigail Ruff H, whoever you want to call first, call the witness, and then the other should just leave the room.
All right, I'm going to call Katie first.
Okay, Mr. Shropsy, is that, it's a little unconventional, but is that, are you satisfied with the
Yeah.
sequestering?
It's about as good as we're gonna do. I'm fine with that.
Okay, good.
Yeah.
All right. Okay, so I heard Katie. What is Katie's full name?
Catherine Ruff, RUFH.
Ms. Ruff, I'd like you to please stand if you could and raise your right hand. I'll do the same. I'll move the camera here. This is unusual. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. All right. Please be seated and then state and spell your name for the record.
Sure, it's Catherine, Katherine. And last name is R-U, F as in Frank, H as in Harry.
And you pronounce it Miss Ruff?
Or Ruff, but.
Ruff. Okay, thank you. All right. Ms. Collins O'Hara, you may question the witness.
Thank you, Your Honor. And it's Miss Ruff. Is that pronouncing it correctly? Thank you. Miss Ruff, were you present at the La Paz restaurant on August 3rd, 2019 in the evening?
Yes, I was.
And what were you doing there?
We were all meeting to go to dinner.
And who's we?
My daughter, myself, a friend of ours, my sister, her husband. I think that covers everybody.
Okay.
If I can stop there, just a couple things that I didn't quite catch. Where were you?
It's a restaurant in Stoughton.
What's it called?
I'm not even sure how to say it, honestly.
I
La
know.
Paz, I think, LA space AZ.
Laz Bistro.
Yeah.
That's
Okay.
before, there you go.
And then what was the date? I missed that.
I asked her about August 3rd, 2019.
Okay. All right. I'm sorry for interrupting. Please proceed.
I'm often told I speak too quickly, so slow me down if you need to. And did you witness anything out of the ordinary on that evening?
Well, we went to meet and so we missed the restaurant, so we had to turn around, but my daughter was already parked there. So we went around and came and parked on the other side of the street. So at that point I was out of the car waiting to cross the street because a truck was coming. And as the truck got closer, I realized she was kind of turned to the side, head down, and wasn't looking, and then just straight into the car.
Can you describe the vehicle that you saw, the truck?
It was a red, I think Dodge truck. I'm not so great at my vehicles. Sorry. It was a big red truck.
And when you say the person was turned to the side, are you referring to the driver?
Driver, yes.
Okay, of the red truck?
Of the red truck, right. She was turned kind of looking down.
And where was your daughter parked?
She was directly like across the street and diagonal to me, just a little bit to guess the left.
Okay. And was she parked in front of the restaurant?
Yeah, about a space or two away from the restaurant.
And can you describe the collision as you saw it?
Fast and horrifying to watch something like that. Yeah, it was just one of those things where you see it in slow motion and you can't do anything to stop it.
And your daughter was in the driver's seat of the car that was hit?
Yeah, she was in the driver's seat. Her boyfriend was in the passenger seat. They were just parked waiting for us to get across the street.
How old was your daughter on August 3rd, 2019?
Oh goodness, 17 still? I want to say she was still 7. Yeah, because I think she would turned 18 in December that year.
And where did the truck hit your daughter's vehicle? Where on the vehicle?
The back corner, I want to say more like, it's kind of in the middle, but more towards the right end of the back, more towards passenger, middle passenger. I mean, the truck was a lot bigger than her car, so it took up most of the back of the car, I would say.
What kind of vehicle was your daughter driving?
Suzuki Vitara, just a little silver, a little mini SUV.
What damage was there on your daughter's vehicle following the collision?
Not object to relevance, Judge. It's irrelevant.
Overruled. I want, you may answer the question.
It was, I mean, it was totaled, obviously, not that that would have been too hard. It was an older vehicle, but I mean, the back end was completely, I don't know, pushed forward, and the front seats, the whole car was kind of like this, like everything got shifted. So like the front seats were closer to the driver's seat, and then the passenger seat kind of was back in an angle, so it like, if that makes
Since
sense.
this is unusual, since it's a video, I'll make a note for the record that the defendant held her hands up and we're moving it horizontally.
I don't know how to explain it, but yeah, it kind of just seemed to jar the whole car at an angle, basically.
What happened to the truck after the collision?
The truck kind of bounced off of her car and then went into, I don't remember if it was like a step or a corner of the restaurant building, basically.
So it collided with the restaurant building?
Yeah, after it hit her car, it bounced, because her car was in park, so it just bounced off of that and then angled kind of into the restaurant there.
Did you see if there was any damage to the building?
I mean, it was brick. You couldn't really tell because I mean the whole truck was covering the building. So no, I have no idea. And at that point, I wasn't even looking. I was at my daughter's car by that point.
And you said your daughter was parked at the time of the collision, is that right?
No. They were just parked talking, waiting for us to get across the street. She didn't even see it coming, or if she did, she doesn't remember.
Objection, speculation.
Sustained. I'll disregard that last answer.
I'm sorry.
And do you remember what about what time it was that you observed this?
I don't. I'm sorry. It was in the evening. It was around dinner time because we were all meeting to eat dinner. But for us, that could have been anywhere between 5:30 and 6:45. It was still light out. I know that.
All right, I have no further questions for this witness.
Mr. Shirafzi, any questions for this witness?
I have a few. Ms. Ruff, did you give a statement to law enforcement or the police that evening?
I don't know about a statement, but I believe I spoke to them. Yes, if I remember right.
Okay, not necessarily if you wrote something out, but you had a conversation with an officer about what had happened.
Yes.
Okay.
I'm pretty sure, yes. There was a
Okay.
lot going on afterwards, but I want to say I did speak to one of the officers at some point during that time period.
Okay. And where this happens, tell me if this is right. It's on East Main Street, is that right? If you know the street.
I think it is called East Main at that point, but yes, it was Main Street.
Okay. And it appears from the information that I have that where your daughter, and I'm not blaming your daughter, so don't take it that way, that there's that portion of East Main Street kind of curves or turns a little bit. Is that fair?
Yes, that is correct.
Okay. And Mr. Shirafzi, sorry to interrupt you. If you could lean forward a little bit, you're fading in and out a little bit.
Okay, sorry. The closer I lean, the bigger my head gets, and that's a problem.
That's okay. Me too.
So, Ms. Ruff, where your daughter, I know she's parked, where she's parked is kind of on, right after the kind of, the road makes that kind of turn or curve. Is that fair?
Yeah, I mean, she was past the curve by a little bit, but yes, after the curve, she was parked probably a spot or two away from where it starts to straighten out again.
Okay, so I guess all I'm saying is where this happens, it's not a straight, sometimes we think of roads as just straight. It wasn't straight at the time. Okay.
It was not straight. It is not straight.
Okay. And if you know, are there, sometimes when we park on the street, there's not actual like parking lanes. Was there a parking lane there?
Our parking spots there, little white marks,
Okay. And
at least that I remember.
okay, so you said that, I want to make sure I have this right. So you say you see the vehicle kind of coming, and you gather from what you're seeing that the vehicle is going to strike your daughter's vehicle. Is that right?
Yeah.
Okay. And how, you made a statement of what you observed with the driver of the other vehicle. How long did you see the driver? I mean, how long were you looking at the driver?
I don't know. 4 or 5, it's so hard to say. 4 or 5 seconds, maybe.
Okay.
Because I was going across the street, so I saw the truck coming. I waited, I watched it, and then I noticed she wasn't looking, and so then I, of course, kept watching it. So yeah, maybe 4 or 5 seconds.
Could you tell what she was doing?
I couldn't. She was bent down looking, and it didn't even look like she was just looking at a phone. She was kind of angled this way. She was smoking, but other than that, I don't know if she was just trying to grab something, or I'm not sure.
Okay. Ms. Ruff, I don't have any other questions for you, ma'am. Thank you.
Ms. Collins O'Hara, anything on redirect?
No, Your Honor.
Okay, thank you, Ms. Ruff. The city may, you are excused, so I think that, but why don't we keep it consistent, and if you probably could leave the room. Do you want to call the other civilian witness, Ms.
I
O'Hara?
say, Your Honor, I don't think I need Abigail's testimony as well, so I think
Okay.
they can be off the hook for the night.
Okay, thank you. Mr. Shropsy, any reason to keep the witnesses here?
No.
Okay, thank you, Ms. Ruff. You may disconnect, and thank you for your testimony.
All right, thank you.
Thank you.
All right. Ms. Collins O'Hara, any, do you have any other witnesses?
I do. I'd like to call Officer Knick, please.
All right. Mary, you can bring him out of the waiting room. Oh, you're working on it. Thank you. Officer Knick?
Hey.
Officer, Mr. Knick, can you stand up? We'll do this again. Raise your right hand and repeat after me. Or actually not repeat after me, but I'm going to give you the oath. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Please be seated and state and spell your name for the record.
Yep. Last name's Knick. It's Knoeck.
All right. Ms. Collins O'Hara, you may question the witness.
Thank you, Your Honor. Mr. Knick, where are you employed?
Full-time at the City of Stoughton Police Department.
How long have you worked at the City of Stoughton Police Department?
Worked there since May of 2018, but have been an officer since January of 2013.
And where was your other officer experience?
Town of Madison Police Department.
Approximately how many OWI investigations have you been involved with in your law enforcement career?
Say, give or take 70 or 80.
Have you received specific training about determining whether someone is under the influence of alcohol?
Yes.
When did you receive that training?
Both in the academy, plus I went to A-Ride school, which is also involved with that. Plus we have in-services and refresher trainings as well.
And have you successfully completed your training in this area?
Yes.
Did that training educate you in the indicia of intoxication and impaired driving?
It did.
Part of that training, did you become certified to administer field sobriety tests?
Yep, I have been certified for that.
And were you certified to administer those tests as of August 3rd, 2019?
Yes, I was.
I'm going to ask you about that evening, August 3rd, 2019. Were you on duty that day?
Yes, I was.
How did you first become involved with the incident that led to these pending citations?
Well, just prior to 7 p.m., I believe it was, officers, including myself, were dispatched to 419 East Main Street for a report of a crash with injuries. And that is how I got the initial information from dispatch. And that's why I responded there.
What is located at 419 East Main Street?
I believe it's Las Bistro bar or business.
Is that address located in the city of Stoughton, Wisconsin?
Yep, Stoughton, Dane County, Wisconsin.
And that's within your jurisdiction when you're an officer of Stoughton?
Correct.
What did you observe when you arrived at the location?
I observed that there did appear to be a car crash. It's found that a red pickup truck had crashed into a legally parked car on the south side of the road.
You said crashed into an illegally parked car?
Legally.
Legally, thank you. Where were the vehicles located when you arrived?
I believe the truck was off the roadway.
Do you recall where the legally parked car was when you arrived?
I don't know.
Did you identify the driver of the red truck?
I did. I identified the driver as Jody Risden. I think that's how you say her name.
How did you identify her?
I don't recall how.
Would it generally be your practice to check the driver's license?
That would be the go-to, yes, driver's license. And I recall that the vehicle is also registered to her, the red pickup truck.
Did she identify herself to you as Jody Risden?
Yes,
Did she say that she owned the vehicle?
I don't recall if she said she owned it. I just know when we ran the information, the vehicle was registered to her.
Did you talk directly to Ms. Risden?
I did, yes.
Okay, what did you do at that time?
I spoke with her about how the crash occurred, and I recall her saying that while she was driving, she was looking at her navigation, but she wasn't sure the best way to leave town. And while she was looking down is when the car crash occurred.
Did she state where her navigation was?
It was in a secure holder inside of the vehicle.
Was it on her cell phone?
I don't recall exactly.
But she stated that's where she was looking at the time of the crash?
I know she said she was looking down at her navigation, then when she looked up, she got in the crash.
What did you do next?
When I was talking to her, I could smell a moderate odor of intoxicants coming from her breath. I noticed her eyes were bloodshot and glossy.
Did you note anything else when you were speaking with her?
I believe her speech was slurred to some point, to some degree.
Did you ask her any questions about her drinking that day?
Yes, I asked her about drinking alcohol, and she said that she did make herself a drink while out on a boat. I believe it was a Crown and Coke. And she said this was at approximately noon. I think she also said she ended up dumping half of it out, maybe.
Did she say anything about her level of intoxication?
She said she could definitely feel it after even one drink.
What did you do next?
I asked her if she'd perform standardized field sobriety testing.
Did she agree to do that?
She did. And then we went into the parking lot of the fire department, which is level, is light and free of debris.
What was your basis in asking the defendant to perform the field sobriety test?
Well, it's the totality of everything that went on so far, to include the crash, first off, her admitting to drinking, her odor of intoxicants, bloodshot and glossy eyes. All of that told me that we did need to do standardized field sobriety testing.
Can you do a brief explanation of what the field sobriety tests are used for?
So the field sobriety tests are used to determine if an individual is impaired by the use of intoxicants. and there are 3 standardized field sobriety tests. You got the horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand test.
Did you perform the horizontal gaze test?
I did.
Can you take us through the administration of that test, please?
Yeah, I provided her with instructions. I did ask her if she wears glasses or contacts. She did say she wears glasses, but they were currently in her vehicle. Then I gave her instructions on how to perform the test. And then I began the test using my pen as the stimulus.
Did she make any statements to you about her ability to perform the test?
She did inform me that she has Lyme's disease. I believe she said something about her cognitive being off.
What did you observe in administering the test?
I saw a total of 4 out of the 6 clues. There was lack of smooth pursuit in both the left and right eye, and there was sustained and distinct jerkiness in both the left and right eye as well. I did not see nystagmus prior to 45 degrees. However, I did see vertical nystagmus.
And what conclusion do you draw finding 4 out of 6 clues?
Well, that is indicative of impairment to the tune of 88%, as long as there's 4 clues present.
What test did you do next?
The next test was the walk and turn test.
Can you take us through your administration of that? Thank you.
Sure. For the walk and turn test, first I asked if there's any issues with the hips, knees, legs, or ankles. She did mention that due to Lyme's disease that her gait could be off. Then I had her assume the instructional position. Then I explained the test to her. Then I also demonstrated the test to her. Then I made sure she understood the instructions to the test.
Did you speak to her at all about her footwear?
She did have, I think it was sandals on, and I did give her the option to take them off if she wanted, but I believe she chose to keep them on.
What did you observe in the test?
During the test, I observed 4 out of the 8 possible clues for the walk and turn test. The clues I observed was she wasn't able to stay in the instructional position. She started before I was done explaining the test. And she also missed touching heel to toe on the first set of 9 steps, as well as the return 9 steps. So that's where the 4 clues are from.
What did that indicate to you if there were 4 out of 8 clues?
That's indicative of impairment as well, somewhere near 80%, I believe.
What was the last test that you gave?
The last test was the one-leg stand test. So the one-leg stand test is where the individual raises a foot of their choice. I guess I can go through the process for the one-leg stand test if you don't. Okay.
Thank you.
So I explain the test to her, and then I demonstrate the test to them, and then I ask them to perform the test.
What did you observe during Ms. Risden's test?
During the test, I observed 2 out of the 4 possible clues. She put her foot down during the test, which is 1 clue. And then she also raised one of her arms in excess of 12 inches away from her body, which is also another clue. And 2 clues on the one-leg stand test is also indicative of impairment, around 80%, I believe.
And the way you performed those 3 field sobriety tests, is that consistent with the training you've received?
Yes, ma'am.
Based on everything you had observed, totality of the circumstances and the field sobriety test, did you form an opinion about whether Ms. Risden was under the influence of alcohol and impaired at that time?
Due to the test and the totality of the circumstances, I did believe her ability to operate a motor vehicle was impaired. Yes.
At that time, did you transport her to the Stoughton Police Department?
Yes, I did.
And what did you do next?
I brought her inside of the police department, and that's where we do our paperwork, as well as the 20-minute observation period prior to doing the evidentiary chemical test.
And did you go through the informing the accused form with Ms. Risden?
Yes, I did. I read that to her verbatim, as I've been trained to do.
Your Honor, I did send that as an exhibit for the court. So I don't know if screen share is the way to handle it. Officer Connect probably does have a copy with him with his report.
Okay. I did receive Exhibit 1 labeled informing the accused. Mr. Shropsey, did you receive that as well?
I did, yes.
Okay. And then Officer, is it Connect?
Yes.
Did you receive the informing the accused Exhibit 1?
I did. I don't have it in front of me, but I did
Okay.
briefly look over it prior to the hearing.
Okay. All right, Ms. Collins O'Hara, you may proceed.
Thank you. Are you familiar with the document we're describing, the informing the accused, that's been marked as Exhibit 1?
Yes.
And did you sign that document as part of your procedure?
Yes.
Did the defendant agree to submit to the chemical breath test?
They did.
Okay. Your Honor, I'd like to move the exhibit into evidence.
Mr. Shropsey, any objections?
I don't have any objections.
Okay. Exhibit 1 is admitted into evidence.
Thank you. Officer Knick, what did you do after after Ms. Risden agreed to do the chemical breath testing?
At that point, I started the 20-minute observation period.
What is the purpose of the 20-minute observation period?
It's to make sure they don't smoke, eat, regurgitate, or have any item in their mouth that might contribute to residual mouth alcohol.
Did you observe the defendant do any of those behaviors during the 20-minute observation period?
No.
And another officer was also present during this period?
Correct. Sergeant Miller was.
Okay. Why were you both present?
I believe that I'm not 100% sure. I would imagine I had to leave the room to write the other ticket, so he took over to watch her during the 20-minute observation period in my absence.
And the protocol is that at least one officer needs to be with the defendant at all times?
Yes, in close proximity to make sure they don't do any of those things previously listed.
How is the chemical breath test taken?
Inside of the Stoughton Police Department, there's an intoximeter EC/IR2 machine that is an evidentiary chemical test of your breath. And I'm certified in its use, therefore I'm able to administer the test.
When did you receive your training?
I don't recall when I received it. I know it was back when I was working for the town of Madison, but we do have update and refresher trainings on that as well.
And you were certified on August 3rd, 2019?
Yes. My certification has never lapsed in that.
Approximately how many of these tests have you administered?
It's hard for me to say because sometimes there are officers that aren't certified in it. So I've had administered it for those officers. So it doesn't necessarily correlate with how many OWI investigations that I've done. So I'm not sure.
Would you guess it's more than 100 times?
I would say somewhere in that ballpark.
Did you administer the test to the defendant in this case pursuant to the prescribed procedure you've been trained in?
Yes. And I did administer it, yes.
And Your Honor, I think we have that, I believe is Exhibit 2. Let me double check.
It's 3, Amy.
Is it 3? Thank you. So much easier with paper in front of you. All right, and Officer Knick, you did have a copy of the intoximeter report related to this case that you reviewed today?
Correct.
Okay. And that has been marked as Exhibit 3. Do you recall what the value, the reported value was on the intoximeter results?
I do. The final reading was 0.09.
And did you sign those results?
Yes.
Your Honor, I asked to move Exhibit 3 into evidence.
Attorney Shropsy, any objections?
No.
Exhibit 3 has been marked and I'll admit it into evidence.
Thank you. Did you get adequate breath samples for the intoximeter?
Yes.
And can you explain to us what the 0.09 result means?
Well, what
Hold on a
the
second.
machine does.
Hang on, Mr.
I would
Officer
object,
Peck.
Judge, it's a legal conclusion. The test speaks for itself. It's a legal conclusion as to what.
Objection sustained.
What did you do following the intoximeter test?
I completed additional paperwork with the defendant, such as the administrative review request form, the notice of intent to suspend form, and usually the alcohol/drug influence report form is along with that too.
What citations did you issue to the defendant?
Would have been operating while intoxicated. Then after getting the test results, operating with the prohibited alcohol content, inattentive driving, and failure to maintain control.
What was your basis for the inattentive driving citation?
Basis for that was her admitting to looking at her navigation and looking down at her navigation and subsequently not looking what was going on in front of her and crashing into a parked car.
What about the failure to keep the vehicle under control?
For going off of the lane of travel, so as it was already said, it was a parked car, so it's not in the middle of the road, obviously, a legally parked car. So she did have to go out of her lane and fail to maintain control of the vehicle to hit a car off the roadway.
And what happened to the red truck after the collision with the parked car?
I do not know.
Okay. Based on your entire contact with the defendant throughout that evening, did you form an opinion about whether she was under the influence of alcohol that would impair her ability to operate a vehicle?
Yes, she was unable to safely operate a vehicle due to her level of intoxication. It was her ability to operate the vehicle was impaired.
I also have Exhibit 2, which I don't believe the witness has a copy of. I could do a screen share, or if the court would like to do that.
Mr. Shropsy, have you received Exhibit 2?
I have, if we're talking about the 120-day maintenance log, I have reviewed it, and I don't need the officer to lay any further foundation. If it's going to be admitted, I'm fine with that.
Okay, then I would just move to admit Exhibit 2 into evidence.
The court will receive the marked Exhibit 2 and admit it into evidence.
Thank you. All right, I don't have any other questions for Officer Knick.
Attorney Sharafi Cross?
Officer Kinnick, did you speak to a witness, Kathleen Ruff, if you recall?
I do not recall, no.
Okay. And you had given a little bit of information regarding your training and experience as a law enforcement officer. And I think you had said, if I have it right, the number of OWI investigations that you have conducted is somewhere between 70 and 80. Is that right?
That is
I'm not holding you to it.
that's a rough ballpark estimate just off the years I've been in law enforcement.
Yeah, no, I'm not looking for a specific number. Can I ask you this, of those, I'm going to take it one step further, of those 70 to 80 investigations that you kind of have delved into, what percentage of those do you think lead to arrests?
OWI investigations in general, do you mean?
Right. I'm not trying to trick you. I think you had said, and I'm not holding you to this number, but you said somewhere between 70 and 80 investigations. How many of those investigations, what percentage of those investigations do you think lead to arrests?
Right. When I thought about that number, I was already thinking about arrests. I've had other OWI investigations where it did not lead to an arrest, but I wasn't counting that as part of that number.
Okay. So the number of investigations is higher than 70 or 80. You're thinking 70 or 80 arrests, more investigations.
Yes.
Okay. And can I ask you, based on your best estimate, what percentage of investigations lead to arrests for operating while intoxicated?
I would say maybe 75.
Okay. Okay. And when you make contact with Miss Risden, she's not in her vehicle when you initially make contact. Is that right?
Yes.
Okay.
You're correct.
Do you notice any difficulty? Is she having any difficulty or exhibiting signs of impairment in terms of her balance or anything like that when you initially make contact with her?
I don't remember if there was issues with her balance when I first made contact with her.
Okay. And her vehicle resulted in airbag deployment. The accident resulted in her airbag being deployed. Is that right?
I believe that's correct.
Okay. And so do you notice, and I know the video's been destroyed or whatever, but do you notice whether or not she suffered any injuries from airbag deployment to her face?
I don't recall. I do recall asking her if she needed medical attention or an ambulance at one point. I know she denied that.
Okay. How does, if at all, how does an accident and airbag deployment impact your decision to have someone perform standardized field sobriety tests?
Can you ask that again, please?
How does an accident where there's a motor vehicle crash, and there's been testimony that the one vehicle was totaled. How does a motor vehicle crash to the level that this one was with airbag deployment? How does that impact your decision on whether or not to conduct standardized field sobriety tests of of a suspected person?
Well, short answer is it depends. Obviously, if they're injured as a result of the crash to where they need medical attention, that would come first. However, if they're still able to walk and talk and agree to do field sobriety testing, I would still attempt it.
Okay. You're not allowed to take any kind of thing into consideration in terms of they don't get the benefit of the doubt if they've been in an accident or anything. You still have to score the test the same way every time, right?
Yes, that's correct.
Okay. So you make contact with Ms. Risden. She hands you her driver's license. Is that fair?
I don't recall how I identified her, but I normally would ask for a driver's license, yes.
Okay. And I know there's been some conversation about this navigation. She tells you she looks down for just a brief moment. Is that right?
I don't recall for how long she said, but I know she said she looked down at it.
If your report indicated that she said she looked down for 1 second, does that sound?
That's what my
reasonable?
report says. I would believe that, yes.
Okay. And she tells you that her navigation is secured in a holder in her vehicle. Is that right?
Yes.
Okay. You don't have any information. Well, I'm asking you, do you have any information as to how fast she was going?
I don't know.
Was that and again, don't take this as a criticism, was that a question that you had asked anybody that was there?
Generally, yes.
In this case?
I don't recall if I asked anybody that question there.
Okay. All right. Now I want to ask you some questions about the field sobriety test, if I could. You said you're certified in those?
Yes, sir.
Okay. So if I said to you, your training and experience tells you that the HGN test is supposed to be the most accurate predictor of whether or not a person is at or above the legal limit, would you agree with that?
That test does have the highest percentage of being indicative of impairment if you get a minimum of 4 clues.
Okay. Now, so I have this right. So there's 3 separate kind of sub-tests that you do on the HGN, is that right?
There's a total of 6 clues that you're looking for, but it's 3 is just for each eye.
Okay, but there's 3 different tests. They're smooth pursuit, nystagmus prior to 45, and maximum deviation, nystagmus at maximum deviation, right?
That is correct.
Okay. So if you can see me, officer, the smooth pursuit test, what you're looking for is to see if a person's eyes show nystagmus all the way across their field of vision, from endpoint all the way to their nose, continuing on all the way to endpoint and back, right? That's lack of smooth pursuit.
You're looking for the jerkiness in the eyes. Yes.
Okay. And you say that you observe that, right?
Yes.
Okay. So can you explain to me, if you observe nystagmus or lack of smooth pursuit, how is it possible that you would not observe nystagmus prior to 45?
Well, prior to 45 would be usually with people with higher alcohol concentration. So it's actually very normal to observe lack of smooth pursuit without the prior to 45 degrees.
How's that possible? When you're doing lack of smooth pursuit, you see it prior to 45, right? You see it at 0 at their nose, correct?
Well, it's just smoothly tracking.
Correct. And that's what you're looking for, though. Yes?
Not tracking the stimulus smoothly. Yes.
Correct. So if you see it all the way across their field of vision, how is it possible to not observe it prior to 45? Explain that.
You're looking at the whole spectrum when you're doing it.
Correct. So if you see it through their entire field of vision, how is it possible that you don't see it prior to 45 degrees?
I don't have a scientific explanation for you. I don't know.
You would have to see it prior to 45 if you see it through their entire field of vision, correct?
I understand what you're saying, I believe. I don't have the answer for you, though.
Well, if you see it prior to 40, if you see lack of smooth pursuit, then by definition, if we're taking this to its logical conclusion, the lack of smooth pursuit and prior to 45 would automatically lead to a fail, right? That'd be 4 clues, yes?
So the lack of smooth pursuit and what?
If you have a lack of smooth pursuit, I know you can't answer this, but if you have lack of smooth pursuit, that is, tell me if I'm right, that is across the subject's entire field of vision, they would then have to have nystagmus at 20 degrees or 30 degrees or 40 degrees. And if they had that, by definition, then they fail that test. So if they have lack of smooth pursuit, they by definition fail the HGN, right?
They don't fail, that would be 2 clues.
Okay. Okay. Now you ask Ms. Risden if she has any physical disabilities to do the remaining 2 tests, which are they require some physical, they're physical tests, right?
Yeah, well, they're divided attention tests, so it's, yes, part of
Okay.
it's,
Why do you ask her if she has any physical disability?
so I can note it in the report.
Okay. So if she has physical disabilities, she's still doing that test? You're just going to note it?
Depends to what extent.
Okay. Are you aware of, and I know you're not a medical doctor, are you aware of any of the physical disabilities that can be associated with Lyme's disease, joint problems, anything like that?
No, sir.
Okay. Okay, so the first test that you have her do is the first of the divided attention tests is the walk and turn, is that right?
Yes.
Okay. And I think that you had said that she had 4 clues on that test.
Yes.
All right. And that was, she has to stand in a, I'm not going to do it here, but she has to stand in a position with 1 foot in front of the other while you tell her or explain to her the test. Is that right?
Along with her arms down at her sides. Yes.
Okay. And if she breaks that position, that's a clue of intoxication, right?
That's a clue on the test. Yes.
Okay. Or if she starts the test, and in this case, you're saying she started the test too early, right? Before
Yes.
you were done explaining.
Mhm.
You gave her a clue for failure to walk heel to toe on the way down, and then a clue for failure to walk heel to toe on the way back, right?
Yes.
You'd agree you can't do that. You can't get multiple clues for the same alleged violation, right?
Well, the 9 steps, the first 9 steps and the return 9 steps are 2 different. You can have a clue for each.
Okay. So then you said there's 8 total clues?
Yes.
Okay. So if I break the stance, that's a clue, right?
Correct.
If I start too early, that's a clue, right?
Correct.
Okay. So on the way down, if I raise my arms, that would be another clue. That'd be 3, right?
Yes.
If I step off the line, that'd be 4.
Yes.
If I miss heel to toe, that'd be 5.
Yes.
Okay. If I do an improper turn, that would be 6,
Okay.
right?
Believe so.
If I stop, that'd be 7. Right?
No, we
I
already
can't
said
stop
that.
walking. Right? So if
We
I'm
already
at
said
7 right, I'm sorry?
Thought you already said stop walking.
No, if I stop walking, that's 7. So then you're telling me on the way back, I can get those 7 clues again to now get us to 14 clues on an 8-clue test, right?
I believe it's just the heel to toe on the forward and backwards.
So raising your arms, you don't get extra points if I raise my arms on the way down and on the way back. That's still just 1.
Believe that would, yes.
It's just the heel to toe that you're saying that on.
Believe so.
Okay. And the one leg stand, one of the clues you mentioned is that she raises one of her arms. How far did you say she was?
I noted if it's in excess of approximately 12 inches.
Okay. And is that the number that you've been trained to look for?
Believe so.
Okay. Is it that she raises one arm or both arms?
Believe she raised one arm.
No, I know that you're saying she raised one arm, but is one arm a clue or does she have to raise both arms like an airplane to get a clue?
One arm can be a clue. It's pretty much trying to keep your balance.
Okay. Okay. And then now you had mentioned you then ultimately, I understand, placed her under arrest.
Mhm.
That you read her what has been marked and moved into evidence is the informing the accused form, and then you then I think you said you begin after you do that, you begin the 20-minute observation period. Does that sound right?
Yes.
Okay. And tell me if I have this right. The 20 minutes you're doing that, and I think you mentioned there's a concern about residual mouth alcohol, or that's why you do it, so there is no residual mouth alcohol.
Yes, we make sure they don't have anything in their mouth like gum or other objects like that that might contribute to it.
Okay. So can I just, I know because we don't have videos and it's been a while, I'm just gonna ask you if you recall. So when you, after you read her the form, do you immediately begin the 20 minutes or do you like do something else for a minute or two? How do you normally, or how would you do it in this case? I guess I don't care how you normally do it. I'm just know what you do.
Well, I mean, like you said, it was a long time ago, but generally I would read the form, just complete the form with my signature and everything like that.
Mhm.
And then I would look in her mouth just to make sure there's no objects in there or any gum or anything like that that might contribute to it.
Mhm.
After seeing that they have nothing in their mouth, then I would start it.
Okay. So if I told you that the informing the accused form was finished being read to you or being read to her by you with your signature at 7:33, she blows into this machine prior to the 20 minutes being up, according to that number on the on exhibit number 3, that there wasn't a 20-minute observation period based on those times. Do you have an answer for that?
I don't.
Okay. And you didn't do, again, you're going to take this as a criticism. It's not, you didn't do the entire 20 minutes. You had to leave the room for some period of time. And you had someone else, the sergeant either step in. Was the sergeant in there already or did you ask him to step in?
I don't remember, but if he wasn't in there, I would have had him come in there to watch her.
Okay. Officer, I don't have any other questions for you. Thank you for your time.
Ms.
Thank you.
Collins, anything on redirect?
One moment, Your Honor.
While you're taking that moment, I'm gonna grab some more papers, so just give me a minute as well.
Thank you. Your Honor, I don't have any further questions.
Okay, any reason to keep Officer Knick around?
I have no reason, no, he can be released.
Okay,
Your Honor.
thank you, Officer Knick. You can disconnect from the phone call. Thank you.
Thank you.
Does the city have any additional witnesses?
Yes, Your Honor, I have one other officer. He should be in the waiting room.
Okay. Officer Miller?
Is he frozen on your computer?
He is now.
Yep.
Okay.
So let's see if we can hear it. Officer Miller, this is Judge Rothy. You're frozen on our screen. Okay, Officer Miller? You're muted right now.
Okay, I can hear you now. My internet was.
Right, you froze up for a little bit. Okay, I'm gonna ask you and you are Officer Miller?
Yes,
Okay, I'm asking you to stand and raise your right hand. As I give you the oath, do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated and state and spell your name for the record, please.
Sure. My name is Robert Miller. It's Robert. Last name is Miller.
Ms. Collins O'Hara, you may question the witness.
Thank you, Your Honor. Sergeant Miller, were you on duty on August 3rd, 2019?
Yes.
Okay. And did you work with Officer Knick in doing the testing and observation period for Miss Risden at the Stoughton Police Department that evening?
Yes.
Okay. Do you recall being present for part of the observation period for Miss Risden prior to the intoximeter testing?
To be honest, I don't recall.
Okay. Do you recall anything of being present that evening for the testing?
Yeah, I remember being present. I don't remember doing a sup, so I just remember being on scene. That's as far as I recall.
Okay. Do you remember being in contact with Officer Knick and Miss Risden at the police department?
I don't recall at the police department. However, I remember I was with him while on scene while he did the field tests.
Okay. Did you review the report in this matter prior to your testimony today?
Yes.
Would it refresh your recollection to review your report regarding the observation period?
Yes, it would.
You have a copy of your report with you?
Not handy, no.
Okay. Turner, I do have a copy that I could screen share.
Attorney Schroff, see this is unusual, but any objections?
Yeah, I don't have a report from Sergeant Miller. And I thought he just said, and I could be wrong, that he didn't write a sup, which I'm assuming is a supplemental report.
I believe that's correct. Yeah, I think the report is done by Officer Knick.
So he would have to be refreshing his recollection on a report prepared not by him.
Yep, you're right.
So I'm not convinced he can do that.
Okay, that's fine.
I would agree.
Mhm.
Objection is sustained.
All right, Officer Miller, I don't have any further questions for you.
Attorney Schroff, see anything on cross?
No,
All right. Any reason to hold Sergeant Miller?
no.
Okay. All right. Thank you, Sergeant Miller, for testifying. You may disconnect the call.
Thank you.
Does the city have any additional witnesses?
No, Your Honor.
Okay. All right. Attorney Schroff, do you have any witnesses?
No, sir.
All right. With that, we will close the evidentiary portion of the trial. Proceed to closing arguments. Ms. Collins O'Hara.
Thank you, Your Honor. Looking at the 4 citations related to Ms. Risden, the officer testified his reason for being available at the stop. There had been a collision where the defendant's vehicle hit another vehicle and then also a building when she had bounced off that vehicle, according to the testimony of Ms. Ruff. So there was good reason for him to be there and to be talking to Ms. Risden. In addition, he also observed the odor of intoxicants, the glossy eyes, and the slurred speech, which gave him reason to ask to do the field sobriety tests. We did hear from the officer what he observed during those tests, and that he felt that that gave him probable cause to move forward with the arrest and the additional testing. We have our test, which shows the 0.09 being in excess of the 0.08 limit, showing the prohibited alcohol content. And also the officer's observations finding that she also showed signs of being too impaired to safely operate a vehicle. There are 2 citations related to the driving, the inattentive driving. We heard from both the witness and from Officer Knick, 2 different explanations that the defendant was looking down as reported by the witness and looking down at navigation as reported by the defendant to demonstrate the inattentive driving, which is, let me find the exact citation, 346.89, to be engaged or occupied with an activity other than driving that interferes with the person's ability to drive the vehicle. So her looking at the navigation did interfere with her ability to drive and cause the accident. Failure to keep the vehicle under control. We do have the witness talking about the crash also resulting in the collision with the building, and the officer's report regarding what he learned related to the collision. Attorney Schroff did bring up the informing the accused and the time of the testing. I'm sure there are procedures that the officers usually take. This incident occurred all the way back in August of 2019. A lot of time has passed. I would say the exact time that the officer signed the informed consent does not necessarily mean that's exactly when he started the 20-minute observation period, and that these are procedures that the police follow very carefully in every case that they have, and they are fully aware that the 20-minute observation needs to occur. And the officer, although we did not necessarily get the support of Officer Miller that he was in fact there, we did get the testimony from Officer Knick that if there was any period of time that he was not present, that Officer Miller was present to observe the class. So we ask, Your Honor, that you find Ms. Risden guilty of all 4 citations.
Okay. Thank you, Ms. Collins O'Hara. Attorney Schroff.
Judge, as it relates to the failure to keep the vehicle under control citation, that is cited as violating 346.57 sub 2. That is a speed requirement issue. And if you read 346.57 sub 2, it says no person shall drive a vehicle at a speed greater than is reasonable and prudent under the circumstances, and having regard for the actual and potential hazards then existing. There has been no testimony as to her speed. There has been no testimony as to any other hazards in the road. And I think under the circumstances, there is insufficient evidence to support that charge. As it relates to the prohibited alcohol concentration charge, the testimony, I'm not guessing on this. I'm not saying that there's probably things that are in place. I'm telling this court that I believe the testimony was that the Officer Kinnick, read the informing the accused form, had her open her mouth, look through her mouth, make sure there was nothing in it, and then began the 20-minute observation period. That would be supported in exhibit number 1, which has a time on there, I think of 7:33. You do not have testimony that Officer Miller admitted to participating in any 20-minute observation period. He has no recollection of any of that. He has a recollection of being on the scene, but no recollection of actually participating in it. And if you look at exhibit number 3, that test result is taken inside the 20 minutes. So I'm asking that you actually look at the evidence in the case and find that, in fact, there was no 20-minute observation period done based on the testimony of the officers, at least the officer who had a recollection of it. And to be fair, Judge, he didn't have an explanation for it when I asked him, can you explain that? He said, no, I can't. So there is no alternate kind of theory for you to consider, because there is no other theory at all, other than it wasn't done based on when he was asked the question. So based on that, Your Honor, what I'm asking that you do, and I guess I would just ask you consider this. The 346.89, which is the inattentive driving statute, there is no strict liability. It's not a strict liability offense, meaning if you're occupied and there's an accident, you're automatically guilty. Because I think there are situations in which our phone rings, or we look at something, or we change the radio dial, and that doesn't mean that we're inattentive in our actions. That requires being engaged or occupied with some other activity. I would just ask that you consider that. And I think under the circumstances, certainly the prohibited alcohol concentration charge, as well as the failure to control vehicle, have not been satisfactorily proven, and I would ask that you find her not guilty of those citations.
Thank you. Attorney Shropsy, anything else?
No, I think that's all I have, Judge.
Okay. Ms. Collins O'Hara, anything on rebuttal?
Nothing, Your Honor.
All right, thank you. All right, thank you both for appearing via Zoom during these trying times. I appreciate you guys, or both attorneys, accommodating the court and all the rules and regulations of this. So what we have before the court, August 3rd, 2019, there's a car accident. I will find that it was within the city of Stoughton. Laz Bistro is on East Main Street, and I know that that's been proven that it's within the city. The driver was also identified. What I'm going to do next is I'm going to take a look at I had it up before, the statutes for inattentive driving. Inattentive driving says no person while driving a motor vehicle may be engaged or occupied with an activity other than driving the vehicle that interferes or reasonably appears to interfere with the person's ability to drive the vehicle safely. Oh, we have the testimony of Miss Ruff, and the court finds Miss Ruff to be credible. She said she saw the driver looking away. I don't know if the audio picked it up, but on video, she had turned her, Miss Ruff had turned her body 90 degrees, and based upon her testimony, it was clear that the defendant was not looking at the road, was looking to her side. And the defendant admitted to Officer, find my notes. Officer Knick that she was watching her navigation device, which is consistent with Ms. Ruff's testimony as well. Looking at a navigation device would be engaged or occupied with an activity. This court finds that she was engaged or occupied with an activity that interfered with her driving. So based upon the available evidence before the court will find that the city proved the citation of inattentive driving by clear and satisfactory evidence. The other citation was for failure to keep vehicle under control, and that is 34657 sub 2. And this states, no person shall drive a vehicle at a speed greater than is reasonable and prudent under the conditions and having regard for the actual and potential hazards then existing. The speed of the vehicle shall be so controlled as may be necessary to avoid colliding with any person, vehicle, or other conveyance on or entering the highway in compliance with legal requirements and using due care. Reviewing that, the point most in favor of the city is that the car hit the building. However, there has been no testimony about the speed given or any other hazards. Since there was no testimony about the speed or the vehicle, or if it was reasonable and prudent, the city has not met its burden on the failure to keep vehicle under control, and the court will dismiss that citation. All right, that leaves us with the OWI. Officer Knick's testimony on the OWI has been was uncontradicted. And the court finds Officer Knick to be credible. Actually, the court found Sergeant Miller to be credible that he doesn't know and didn't remember. The indications given the court, first of all, the officer had reasonable suspicion to stop the vehicle. There was a car accident, and I've already found that there was a violation of inattentive driving. What we have before us is moderate odor, eyes are bloodshot and glassy, and the speech slurred to some degree. I'll note for the record that the blood alcohol content was a 0.09, and I do find that Officer Knick's testimony regarding the clues were rather consistent with an 09. You know, that's, as the court's seen many intoxicated driver cases, an 09 is unfortunately on the low level of the spectrum that the court sees. So the fact that it was some degree of slurred speech, a moderate odor, indicates that while not as intoxicated as many drivers, there's some indications. Also that the defendant admitted to one drink, and then more tellingly that the defendant could feel it after one drink. This gave Officer Knick the probable cause to ask for field sobriety tests, the next step up on an OWI investigation. Now the three field sobriety tests, Attorney Schrofsky, I've never heard the argument about the lack of smooth pursuit and the 45 degrees nystagmus. I enjoyed the argument. I liked it. I never thought about that before. But that even if you take the two clues, the 4 out of the 6, that's, again, the Officer Knick's testimony is consistent with the fact that the defendant wasn't as intoxicated as other drivers that the court's seen. But even if you take 2 clues into effect, the court will find that at least 2 clues are noticed on each end. Now, that doesn't give rise to the 88% as the officer indicated, but there are indications. The walk-in turn test, Attorney Schrofsky makes a convincing argument that really he testified as to 4 of the 8 clues, but from what the court could gather of the cross-examination testimony, it was really 3 clues instead of 8. There was 3 clues instead of 4. One of the clues were the same. That's still some indications, but again, it reduces the percentages. The one-legged stand. There were 2 clues out of the 4. Put the foot down, and the other one was raising one arm. I don't have the field sobriety test manual in front of me, so I don't know if one arm is raised or 2, but it is an indication. So if it's 1 or 2 clues, there's still clues present for this. Given all the totality of the circumstances, the court found that it was that the officer did have reasonable, or they actually had probable cause to arrest the defendant for intoxicated driving. Now we get to the clue. So when we look at this, the court will make the finding that given all the clues, given the demeanor, and given the officer's testimony, that the OWI, that she was impaired, the court finds the officer credible, and the court will find the defendant guilty of the OWI, operating one motor vehicle while intoxicated. The last citation would be the prohibited alcohol concentration. Before I decide on that, let me ask both attorneys questions. What is the remedy if the 20-minute observation period is not strictly followed? Ms. Collins-O'Hara, I'll let you go first.
Well, Your Honor, I don't think the remedy is that the intoximeter is incorrect. You would need additional evidence that there was something else that occurs in that 20 minutes to say that there was residual alcohol. We don't have the defendant here to testify to say that there is anything else that occurred during that time to say that the testing was incorrect. So I don't think the automatic remedy is to say that the 0.09 is incorrect.
Okay, Attorney Shirofsky.
Judge, I think the world of Miss Attorney Collins-O'Hara, but I think she's wrong. It's what it is. It's an administrative code violation. So there is a Wisconsin administrative code that requires a 20-minute observation period before a breath sample has been taken. Now, the law isn't suppression, okay, if there isn't a 20-minute observation period. So the court, like all other evidence, you can consider the fact that it is to be done, that there is an administrative code violation. And I think in situations where I probably wouldn't make this argument is test results that are 0.14, 0.15, 0.16, something like that, but where you are as close to the legal limit as Ms. Risden is, like any other piece of evidence, the court can consider the fact that there was an administrative code violation when determining guilt or innocence. The defendant has no burden of proof here, so to require the defendant to testify and to say something, that's not correct. But it doesn't require suppression. So I'm not asking that you throw it out, but there's no question there's been a violation.
I'll note for the record that the officer did not have an explanation. Looking at this, what I have in front of me is the informing the accused. He completed it at 7:33 p.m. That's in Exhibit 1. And so I can editorialize. I wish I had my desk at the bench so I could spread everything out a little bit more. Let me take a look. Let me find Exhibit 3 again. Okay, Exhibit 3. Thank you for your patience. So, in looking at Exhibit 3, the first test was taken at 19:52, which would be 19 minutes. Second test was taken at 19:58. So, while Attorney Shirofsky is correct that there was a 20-minute administrative code violation, the second test was 0.098 and still taken 25 minutes after the informing the accused. The officer did testify that he didn't observe any foreign substance in her mouth and all that. So the court has taken into considerations, but I think that what's clear and satisfactory to the court that there was a blood alcohol content of 0.09. It was above the 0.08. While the court has concerns that the 20-minute test wasn't strictly followed, I don't have anything rebutting the exact alcohol level. Because of that, I'll find that the city's met their burden on the prohibited alcohol concentration. So, all right. Well, actually, normally I would ask for penalties at this point, but the court will, for the inattentive driving, impose the face amount of the citation. For the OWI charges, the court will, since it's a below a 0.10, in fact, Ms. Collins O'Hara is familiar with the court penalties, but Attorney Shropsey probably isn't. Attorney Shropsey, when they're below a 0.15, I give the minimums. So I would give them $150 forfeiture plus costs, 6-month driver's license revocation, 6 points, and of course the alcohol and drug assessment class. All right.
Judge, this case is, I didn't mean to interrupt you, I'm sorry. This case is a little bit older, so she still has, and I don't know what her plan is, but she still has the right to appeal if she wishes.
Correct.
I know that's not the case anymore, but
You stole my thunder, Attorney Shropsey. I was going to say this was before Act 70 was passed, so she has the right to ask for a jury and appeal.
so I'm only asking if you would stay the penalties for the 20 days, just so she doesn't have to reapply to get her driver's license.
Okay.
if that makes
City's
sense.
position on that?
No objection, Your Honor.
Okay, I'll go ahead and stay the penalties, Mr. Shropsey.
Okay, I appreciate that, Judge. Thank you.
Your Honor,
Yes.
if I don't know if this is appropriate, but it is a second first offense, so she would need an IID per state law, so.
Okay, thank you. I was not aware that was the city and Attorney Shropsey aware of that as well?
Yes, Your Honor.
Okay.
I'm aware that there was the reports indicated that there was a. Amy, do you have a certified? I'm not trying to be a pain. Do you have a certified driving abstract to show the prior? Can you get me that? I'm going to ask for the stay anyway, but
I'll grant the stay, but I'll note for the record that if it ends with me, the penalties would be, I would have to order an interlock ignition device be installed for a period of 12 months, and I would surcharge the $50 in addition to the penalties.
okay,
Okay.
very well.
Ms. Collins O'Hara, anything else?
No, Your Honor.
Attorney Shropsey, anything else?
No, Judge, it was good to see you. Thanks.
Thank you. It is good to see everybody, and thank you for being patient with us. I wish we could be in person, but I think this worked about as well as it could have. So
It's nice to see faces either way.
yeah, exactly. So okay,
Thanks,
thank
guys.
you, everybody.
Good night.
Thank you, Your Honor.
Okay, anything else, Mary?
No. that's
Okay.
it.
Okay, great. I will give John my regards, and I will I'll speak. We'll speak as we progress
Okay.
this week.
All right.